don't understand what I'm asking, tell me that. And then you and I will talk about it till we're sure we're on the same page.
Yes, sir.
If at any time during the hearing, you want to talk to Mr. Crawford in private, you just tell me that. I can send you, it's called a breakout room. I send you guys into a room where you can talk and none of us can hear you, okay?
Yes, sir.
Your
All
Honor,
right.
Your Honor,
Yes.
I don't believe we've had a waiver of preliminary hearing in this matter.
Okay, thank you. I will make sure that we get that when we start. All right, let's first things first, call the case. So I will call case number 2019-CR752, captioned State of Kansas versus Richard Radford. Would the parties announce their appearances, please?
May it please the court, State of Kansas appears by Assistant District Attorney Nicholas Campbell.
And please the court, Your Honor, Mr. Radford appears via video from the jail, and with counsel, Radford appears via video at a separate location.
All right. Mr. Radford, we talked a little bit about this plea hearing. To ask you those questions I was talking about, I need to have you sworn in. So if you would raise your right hand, my court reporter will swear you in.
Do you solemnly swear that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right, go ahead and put your hand down. How far have you gone in school, Mr. Radford?
To ninth grade,
All right.
and then I got education in prison.
Okay, you reading right okay?
Yes.
All right. As you sit here today, I know you're in custody, but are you under the influence of any alcohol or drugs or prescription medicine that might cloud your mind, keep you from understanding what we're doing?
No, sir.
All right. You feel like your mind's clear today?
Yes.
All right. You know what you're charged with?
Yes, sir.
You know you don't have to change your plea today. If you wanted to maintain your not guilty plea, you would have an absolute right to a jury trial on these charges. You understand that?
Yes, sir.
All right. At that trial, the state would have to put on enough evidence to prove you guilty beyond a reasonable doubt. You wouldn't have to prove anything yourself. You would have the assistance of Mr. Crawford throughout that trial. He would cross-examine and confront all of the state's witnesses, challenge their evidence. He could call any witnesses you wanted called. If they didn't want to come to court, he could use a subpoena power to make them come to court. You understand all that?
Yes, I'm just tired of being in the county. I just
Sure.
want to get it. They said it'd be until around March till I got to trial, so I just want to get out and go.
Okay. All right. Now, also at that trial, you would have a right to testify, but you'd also have a right not to testify. And if you decided not to testify, the state couldn't use that against you. In other words, they couldn't get up and argue to the jury, well, he must be guilty because he didn't tell you his side. Also, if you were convicted at that trial, you'd have a right to appeal it to the appellate courts. And if you didn't have the money to do that, a lawyer would be appointed to do it for you. Do you understand all of that?
Yes, sir.
All right. And now if you go forward with this no contest plea today, you're going to be giving up all of those rights that I just went over with you. There's not going to be a trial in this case. You understand that?
Yes, sir.
All right. I want to share with you now what was sent to me as the plea petition in this case. I want to ask you if you recognize this document.
Yes, sir. I just went over it with my attorney yesterday.
All right. You understand everything in it?
Yes.
All right. There's a signature there where it says defendant. Is that your signature?
Yes, sir.
All right. Says that you are going to be pleading no contest to count one, that they're going to jointly recommend 12-month underlying sentence and no fine, and that you will be filing a motion for a durational. Is that durational or should it be dispositional departure, Mr. Crawford?
It's durational, Your Honor. The agreement is for a 12-month term. We're of a belief that he'd be a criminal history D, so it normally would be a 24-month sentence. And the negotiation is for an agreement to jointly recommend 12 months.
Okay. Is that your understanding as well, Mr. Campbell?
Yes, Your Honor.
All right. Mr. Radford, is that your understanding of the entire plea agreement?
Yes, sir.
Has anybody promised you anything else to get you to plead today?
No, sir.
All right. Has anybody placed any force or threats against you to make you plead today?
No, sir.
All right. Now, they tell me that they think your criminal history is that of D, as in David. And that's based on the best information they have. When we're done with this plea hearing, I am going to order a pre-sentence investigation. They're going to look into your background and see what your official criminal history is. Everybody will have a chance to make sure it's accurate and all of that. And you understand if there's something there that these lawyers don't know about, that you didn't tell Mr. Crawford about, that you could be looking at a higher sentence than you and he had talked about. You understand that?
Yes.
All right. So what I have to do today, since I don't know what your criminal history is I have to pretend like it's the worst possible criminal history so I can advise you the maximum that anybody can get for this crime. And the maximum is 42 months in prison and a fine of $100,000. Do you understand that's the maximum penalty for this crime?
Yes, sir.
Okay. Do you have any questions about anything that you and I have gone over today?
No, just the sentencing.
Okay. You have questions about the sentencing?
Oh, yeah. Well, I talked to my attorney about sentencing yesterday. See, he was talking about seeing if we could get it to 3 weeks instead of waiting out 6 weeks.
Yeah. All right.
Because he, my criminal history already knows it.
All right. So let me ask you this on that. So is there, Mr. Crawford, been a PSI that has been created and that Mr. Radford's been in ever since?
Not that I know of.
Okay.
I know.
I don't know. I can try and get it as fast as I can. The probation office has to do this PSI. It takes them some time, but we'll get it set as fast as we can.
Our understanding is that he's got one person felony that he's on parole for, I believe out of Missouri, so it shouldn't be too complicated. But obviously, even in these times, the probation department is overwhelmed, I understand. So I just told Mr. Radford that we get it done as soon as possible.
Yeah, it's not Missouri. It's right here.
Oh, it's here. Okay.
Yes, sir.
Do you have a DOC hold right now,
Yes.
parole hold?
Yes,
Okay.
sir.
Do you know, or are you getting a 90-day on it, or?
I don't have a clue. He tried to find out, and my parole officer said they're waiting to find out what I do here.
Right. I got you.
So I don't know if the parole board, do you know if they come here to see me, or do I have to go to prison and deal with that?
My understanding of the process, they don't call it parole anymore. Parole's a totally different thing. It's post-release supervision.
Yeah.
And I think they will send down a decision on whether you should be violated or not. And you would have an opportunity to request a hearing on that. Most people don't. And I'll tell you just frankly, there's a reason for that, because you almost never win and you don't get credit for the time that you wait for that hearing. So people usually take their 90-day setback on something like that. But I can't really tell you how long you've been sitting in here.
I've been in for 2 years, but I was in Johnson County for 9 months of it, and the rest of the time here.
And that Mr. Radford has been in custody here since December 2nd of last year.
All right. Well, yeah, I think we should be able to get you rolling. And in fact, I don't know, we'll talk about Mr. Campbell, see what you think about me ORing him on this case. And then if parole wants to do something with him, that they can. And if they don't, we can just get a sentencing done. It's kind of, I don't know. But is he going to remind me, because I don't have my grid right here in front of me, this 5D is a presumptive probation box, isn't it?
It'll be a border box case.
A border box. All right. Okay.
Then
In any event, let's get back to our plea. So, Mr. Radford, I guess to answer the questions that you asked, we'll see about, 'trying to get this sentencing done as fast as possible. what I would hate to do to you if I let you go on this and they give you your 90 days, then when you're done with that 90 days, instead of just getting to walk, they'll have to ship you back here and put you in here. We're going to have to get you set for sentencing again. You'd probably just spend more time than you would have if you get your sentence, get on your way. So we'll take that up in a little bit, but that's kind of getting ahead of ourselves. Anything about the plea, your rights, what the plea agreement is, what the maximum, anything about that?
Okay.
You have any
No.
questions about any of that stuff?
No, sir.
Okay. Mr. Crawford, do you know any legal reason why your client should not plead no contest?
No, Your Honor.
All right. So, Mr. Radford, as to count one of the information, which charges you with possession of an opiate narcotic drug, to wit morphine, which is a severity level 5 non-person drug felony. How do you plead? Not guilty, guilty, or no contest?
No contest.
All right. I'm going to ask Mr. Campbell to tell me what he thinks the facts would be if this case went to trial. I want you to listen closely because when he's done, I'm going to ask you if that's what happened, okay?
Okay.
And Your Honor, just a couple things. I might have just completely missed them, but did we ever officially waive prelim on this case?
No, Mr. Crawford reminded me and I completely forgot. All right, Mr. Radford, as to this case, there is a separate right to a preliminary hearing. I mean, it wouldn't make a lot of sense to have to do it since it's ending in a plea, but you do have that right. And before we could go forward, you would need to waive that right. Do you have any questions about that?
No, I understand. I waive it. I waive
All
the
right, and
prelim.
Mr. Crawford, as you waive it as well,
That's correct.
Mr. Campbell.
I would also waive prelim. And then one last thing, I'm probably just missed it, was just that the representation of Mr. Crawford, whether it was sufficient or thing like that.
Yeah, I don't. Any complaints about your attorney, Mr. Crawford?
No, sir.
All right. I'll show the parties waive preliminary hearing, bind over for trial, and we'll go forward with the plea. Mr. Campbell, factual basis.
Yes, Your Honor. If this case went to trial, state's evidence would show that on February 6, 2019, officers with the Bonner Springs Police Department responded to, I believe it is 142 Alcott Avenue, which is again located in Bonner Springs, Wyandotte County, Kansas. There they were able to find out that the defendant, Richard Radford, had been staying there. He had a parole warrant. He was eventually taken into custody at that address. A search of that residence did locate in the kitchen, out in the open, a uncapped syringe of a brown liquid that was eventually sent off to the KBI for testing and came back positive for morphine. Again, all in Bonner Springs, Wyandotte County, Kansas.
All right. Mr. Radford, you have pled no contest, which means I'm not asking you if you agree or disagree with that evidence, but you understand that's what the state believes that they could put on if there was a trial.
Yes, sir.
All right, thank you. I will find the defendant has freely, voluntarily, and intelligently entered his plea of no contest to count one of the information. He understands the nature of the charge and the consequences of the plea. There is a sufficient factual basis, and based on the state's factual basis, I will find the defendant is in fact guilty of count one of the information. Order a pre-sentence investigation be prepared. First things first, Mr. Campbell, what's your position on defendant's bond?
Your Honor, normally when it's essentially he would have served his sentence. We are asking for a 12-month. Essentially, with good time, he would have already served it by now. We usually do not oppose. However, usually with the DOC hold, we usually ask. We're worried about them getting lost or not coming back. However, I would leave it in the court's discretion because I believe he has already kind of served his sentence here. I don't know what's going to happen with DOC, but I'll leave that within court's discretion with those comments.
Mr. Crawford, Mr. Radford, you want me to release him on this case? It might complicate things in the future, but then again, he can always look. He's been in long enough. Parole might not want to do anything with him anymore. So, what's your pleasure?
I can have Mr. Radford make sure he contacts me when he finds out what's going on with parole. I have somewhere the number there myself. I can make that phone call. So if we set it out in a month or whatever, and there's a problem, I can let everybody know and we can make sure that that's all taken care of. I think
All
it's
right.
great that there's the consideration here for letting him go.
All right. I'm going to OR Mr. Radford, and hopefully, like I said, that'll all get resolved before we come back. Let's look for a sentencing date.
Yeah, that way I was going to ask if that way, if they do, then at least I would be able to be at home with my family on Christmas and my
Right.
kids. So,
All right.
and then I could
So-
do something.
Let me put sentencing out for a while since we think he's going to be getting either moved out or hopefully released. I do them on Friday mornings, and like maybe January 29th at 9, Mr. Crawford.
I have nothing scheduled at that time at the moment. That's fine.
Sound
I
good,
don't have
Mr.
anything that
Campbell?
far out, so that works for me too.
All right. So I'm going to do January 29th at 9 o'clock in the morning. Mr. Radford,
January 29th at 9. Okay.
if you are free, you need to keep in touch. Well, either way, you need to keep in touch with Mr. Crawford. Okay, we're going to do it by Zoom again, because we're just trying not to have people at the courthouse these days. If you go to DOC, you also need to reach out to Mr. Crawford and let him know that, so that we can keep track of you. My hope is that they don't take you. And I think there's a decent possibility that that's going to be the case. But you need to keep in touch with Mr. Crawford in either way. Mr. Crawford, I'm going to send you a blank copy of the PSI request along with the emails where you need to send it to. It's basically so probation can reach out to him and set up their PSI. I guess right now you would use Dale as his where he's at.
DOC.
All right.
That's fine.
So it'll be a blank one, and I don't know if you need to like do a meeting with him or
If they
have a
want
phone
me.
call with him to fill out the information, get it over to probation. Okay.
Okay.
All right. January 29th at 9 o'clock. Anything else for our record today?
Nothing by the state.
If you get that sent pretty quick, I can see him this afternoon. I mean, we can get this done.
I will send it as soon as we hang up here. I do have to tell you, as a convicted felon, it's prohibited for you to own and possess a firearm, certain kind of deadly cutting instruments like dirks, daggers, switchblades, basically knives that could be considered deadly weapons. Okay.
Okay. Is there possible to get a no or a recommendation for no prison or treatment?
For parole,
Yeah.
we don't really have a way to do that, and they wouldn't do it for me anyway.
Okay. My family does keep in contact with my parole officer, so I will be in contact with her if I do get released right
Good
away.
deal.
So
All right. Good luck to you, Mr. Radford. We'll see you on January 29th.
thank you so much, Your Honor.
Thank you.
Thanks, Judge.